Safety and Judiciary is hereby convened. I would like to initially start off by thanking my colleagues to my immediate right and to my left, Senator Mike St. Nicholas and Senator Blas McCreadie, for joining us this evening. On the agenda, we have two legislative proposals. One is Bill number 40, which is an act relative to properly classify law enforcement personnel of the government of Guam by renaming attendance officers as truancy officers to reflect practice throughout the United States and classify such officers as law enforcement under the provisions of Public Law 29-105 and to provide uniforms and equipment to truancy officers. That is Bill number 40-33 COR. The second item on the agenda this evening will be Bill number 42-33 COR, which is an act relative to the crime of promoting prison contraband, which may be cited as the Contraband Reform Act of 2015. And as it applies to the open government law, just for the information of members of the public, notifications were sent out on the 4th of March to all the senators, to the media partners, and to the stakeholders. And then subsequent, the 48-hour notification was released on the 9th of March to likewise the senators, the media, as well as the stakeholders. The first legislative proposal, as I read the title a little earlier, is Bill number 40-33 COR, and because we do have a somewhat extensive list of individuals who have signed in, we're going to go ahead and proceed and begin with the overall presentation of the testimonies. So if I can invite the following individuals to please join us up front: Ryan Agigi, Kenneth Charglove, Lourdes St. Nicholas, and Clarissa Charglove. If I can invite the four of you to please join us up front, and you will begin the discussion on bill number and your presentation on bill number 40-33 COR. Before any of you commence with your statements, I would like to recognize Vice Speaker Cruz, who is the acting speaker at the moment. Thank you very much, Mr. Speaker, for joining us in this discussion, this public hearing this evening. Mr. Agigi, if you can pull the mic, please, and turn on the mic and speak directly into the mic and identify yourself for the record, and then proceed with your testimony. Thank you.
Ryan Agigi, School Attendance Officer, DOE, in favor of.
Is there anything else you would like to say with regards to the proposal? Okay. Thank you very much, Mr. Agigi. I appreciate your presence this evening. And Mr. Charglove, I take it you will yield to Mr. Nicholas.
Good afternoon, Mr. Chair, Senator Aguon.
Please proceed.
Senator McCreadie, Senator St. Nicholas, and Senator Vice Speaker Benjamin Cruz. Buenas and half a day. My name is Kenneth P. Charglove, a retired educator from the Guam Department of Education for over 3 decades. I'm here before you this afternoon to provide testimony in strong support of Bill number 40-33. First, I wish to thank the members of this august body for allowing me the opportunity to testify on this very important piece of proposed legislation which greatly affects the Guam Department of Education school attendance officers who also holds the title of Special Duty Marshals, Deputy Marshals. After reviewing the bill, I'm elated to be here this afternoon to share my personal experience as a former school and district level administrator in describing what I have observed in their professional execution of their formal roles on our public school campuses throughout the district. While I did not have direct supervision or manage their day-to-day work activities and functions, I had the occasion to work and observe this group of professional, hardworking, committed Guam Department of Education personnel during my career as an educator. Therefore, I feel competent to provide a snapshot of their work duties and responsibilities. 17 GCA, Chapter 51, subsection 51-101B states in part the Chief Marshal and all marshals and the Chief of Probation and all probation officers of the Unified Guam Judiciary are peace officers. Pursuant to 7 GCA Chapter 8, subsection 8107A, the school attendance officers are classified as special deputy marshals and peace officers. In reviewing and cross-analyzing the standards of all 3 peace officers' positions, the job standards and expectations of the school attendance officers, the special deputy marshals, and the probation officers and the deputy marshals are comparable, if not equivalent, in their formal and official role as peace officers. Exhibit A, and I don't believe I put down Exhibit A, but this is the document I'm making reference to. Cross-analysis of these three positions is provided for your review and information. So, Senators, what we did essentially is that we took the position description straight out of the established and approved Civil Service Commission for school attendance officers. We look at the established Civil Service Commission straight out of those documents and listed them side by side, and we did a comparable analysis of the work. I am not professing that I am human resource, but I have to say that I have enough experience to know that these positions have been carefully scrutinized and analyzed by Civil Service Commission. In fact, some of the wordings in here, I'm going to surmise that really were taken almost directly out of either the probation officers or out of the deputy marshal's lingo. In addition, all three positions maintain and continue to update their professional awareness relative to federal and local statutes, policies, standard operating procedures, and administrative regulations. As special deputy marshals and pursuant to 7 GCA, the SAOs of the Department of Education shall complete a training program developed and adopted by the Judicial Council that is pertinent to their appointment prior to such appointment as special deputy marshals of the Guam Judiciary. SAOs are also required to go through the same tactical training and certifications as deputy marshals and probation officers, including tactical tracking operation, basic officer survival training, expandable baton training, pepper spray training, and high-risk response training shooter on campus. The only difference is that the SAOs are not required by statute to undergo firearms training. I have personally experienced through my years of school leadership, to which these fine men and women who give their all to enforce laws applicable to education and preserve the peace for a safe learning environment for our public school students. Most recently, in late November of 2014, at one of the public high schools, I personally observed the probation officers, Homeland Security, and the school attendance officers of special deputy marshals interacting and coordinating the best possible tactical positions and procedures to provide the optimal safe learning environment for those students who appear to be somewhat, there was an unrest on that campus. And in closing, I wish to inspire this august body to support Bill 40-33. Thank you, and si Zeus Maase.
Si Zeus Maase, Mr. Tragla, for your testimony this evening. Mr. Nicholas, please identify yourself.
Buenas, Vice Speaker Cruz, Chairperson Senator Aguon, Senator San Nicolas, Senator McCreadie. My name is Lourdes San Nicolas, a private citizen and a former school principal with the Guam Department of Education. I appear before this body in support of Bill 40-33, renaming the title of attendance officers to truant officers and including them under the public safety law. Enforcement pay adjustment is commendable of this legislative body. I applaud the initiative to make this a reality for our dedicated and hardworking attendance officers. I speak from my experiences, having had the opportunity to work with various attendance officers at various schools, having been transferred occasionally from time to time. I am not sure if it is pure luck or just as a result of my utmost desire to collaborate and work closely with them. I see their role as an extension of the school administration. Definitely, we all had a goal in common, and that is to ensure that the students successfully graduate from high school and not have them become a part of the dropout statistics. I have witnessed the attendance officers go into the jungles to find truant students. They obviously were taking a high risk, not knowing who could be there or if they would come out of the jungle safe and sound. This took a lot of courage, determination, and perseverance. But they took the risk to ensure that the students returned to school and fulfilled the expectations. I have also witnessed their ability to counsel both students and parents as they prepare the referral to the court. While it may sound as though their role is punitive in nature, they actually took the time to explain the process, what to expect when they appear before the judge, but most importantly, what needs to be done to prevent further truancy problems. They have become the partners of families, working together for the benefit of the students. Attendance officers are very resourceful. In situations where the school administration could not reach the homes due to multiple reasons, particularly because families are transient, especially in the northern part of the island, the attendance officers would try to find the families and help us communicate the message that we need to have a conference to discuss academic and behavioral issues. Their assistance to help us reach the parents is definitely invaluable. I urge this body to pass this bill and at the same time provide the necessary funding for the pay adjustment. Thank you for the opportunity to testify in support of this bill.
Thank you very much, Mr. Nicholas, for your testimony this evening. Just a quick question, because I know that the chairman of appropriations is also here. And in terms of looking at the financial implications, and this is a general question that I will pose also to our school attendance officers at the moment. Would there be any, what would be your response if in fact we make this effective at the commencement of the next fiscal year? Only primarily because of budgetary considerations.
Are we talking now about the financial
Yes.
aspect of the department's budget? Certainly, because we also are very, very sensitive that as the chair of the Finance and Budget Committee, I see it being probably that we may be requesting for an additional funding to support this piece of legislation, only because we know that the department needs every cent to support the current operations and personnel sections.
And that's one of the reasons why I posed that question, because if in fact we consider this and then we look at having it effective on the 1st of October, then the financial considerations would be part of the budget that will be adopted in the next FY.
Right.
So I certainly hope that there will be some consideration on your part, because you're here today extending your support for this initiative. And if in fact we proceed and we pass it and we make it effective as of the beginning of the next fiscal year, I think that there's a stronger possibility of being able to identify the resources through the Appropriations Committee, rather than trying to identify it in this fiscal year. So just a thought of consideration. Any questions or comments from my colleagues? Senator Nicholas? Sure. Thank you very much, Mr. Aguigui and Mr. Nicholas, Mr. Chaglev. Thank you. Mr. Masi. If I can invite the following individuals, please, to join us up front. Clarissa Chaglev, Tara Kitichai, is it Sisette Kitichai? And Sherry Sanchez. If by any chance you want to signify that you wanted to sign in the attendance roster and not necessarily present an oral testimony, then please just identify yourself for the record.
Sherry Sanchez.
Oh, Sherry? Okay. Anyone else? We have Clarissa Chaglev, Tara Kitichai, Siret Kitichai, John Sanchez. If I can invite you all to the front. And like I said, folks, if by any chance you sign the attendance roster specifically to show support, then the committee will recognize that, as opposed to providing oral testimony. Anyone else? Any of those individuals I called in the audience? What about Davina Garrido? Ronald Camacho? Davina, are you going to be providing testimony? Okay, but you signed in specifically to show your endorsement of the proposal. Okay, thank you, Ms. Garrido. Anyone else that I called out? Mr. Camacho, likewise? Okay, so you will not be providing oral testimony, but you signed in signifying your support for the legislation. Thank you. Thank you very much, folks. And that's one of the things that my people are asking is if, in fact, you're coming in to endorse the legislation, and if you don't want, it's not a requirement that you provide oral testimony, but you sign in and signify whether you support the legislation. Of all those that I've called, let me just once again call these individuals just in case they're in the audience. Clarissa Charglove, Tara Kidachai, Sised Kidachai, and John Sanchez. Are you in the audience? You can just signify if in fact you don't want to present testimony, but I know that they all signed in favor of this particular proposal. If not, we'll continue on down the list. Alfred Garrido, please. John Meno, Geraldine Tahadzi, Nadine Calvo. Like I said, if you're here to support and not present testimony, then please signify by raising your hand. We have Santos, Vicente Charglove, and Johnson Nicholas. You're all here specifically to endorse the legislation. Okay, so I take it Mr. Garrido is your point person? Okay. Let me just continue. Please bear with me, folks, in terms of inviting the others who may be here to provide testimony. Stephanie Charglove, Benny Charglove, Carla Borja, Norma Kidagua. Carla, please, if you can join us up front. I take it Stephanie Charglove, Benny Charglove, and Norma Kidagua are also here to support the legislation. Okay, thank you very much for signing in. John Camacho, Doris Camacho, Natasha Garrido, Marlene Papi, and Eric Miller. If any of you are here to provide oral testimony, please join us up front. Otherwise, I will take it that, in fact, you're here endorsing the legislation by virtue of your signature. Okay, so we do have 3 individuals up front, and then we'll go ahead and proceed with the testimony. And Mr. Garrido, you may proceed. Please identify yourself for the record. Alfred, can you pull the mic close? Thank you.
Oh, it's off. There we go. Good evening or good afternoon, Senators. My name is Alfred T. Garrido. I am the Acting School Attendance Officer Supervisor with the Student Support Division, Department of Education. I want to thank you for allowing me the opportunity to provide testimony on behalf of all of the school attendance officers who you see behind me, in favor, of course, for Bill 40-33. Let me begin by answering the question that you all might be asking yourselves. Are school attendance officers truly law enforcement officers? The answer is, without a doubt, yes. School attendance officers, or SAOs, enforce Guam Code Annotated Title 17, which is the Educational Law, Chapter 6, or more commonly known as, to us, the Guam Truancy Laws. The law requires that a child between the ages of 5 until they turn 16 years of age to attend school, and if the child incurs 12 or more unexcused absences within a school year, the law states the school attendance officer is in charge of bringing that matter before the family court. This statute in itself clearly articulates that we, SAOs, are solely in charge of enforcing this law, hence our law enforcement personnel. To further clarify our status as law enforcement, on July 16, 2010, the 30th Guam Legislature enacted Public Law 30-167, which appointed all SAOs as Special Deputy Marshals and required us to complete a training program which is developed and adopted by the Judicial Council of Guam. That same year, we received specialized training conducted by the Deputy Marshals from the Superior Court of Guam and were sworn in as Special Deputy Marshals by the Honorable Chief Justice Robert J. Torres, Jr. Additionally, in December 2014, Bill 418-32 was passed into law, placing all Special Deputy Marshals as Category 2 peace officers under Title 27, Chapter 3, which is the Guam Peace Officer Standards and Training Commission Administrative Rules. Category 2 peace officers are defined as employees of the government of Guam whose job description is of a specialized nature, including the execution of administrative search warrants and investigations of a specialized nature. Significantly, these two statutes collectively recognize and emphasize the importance of the martial functions and duties that we SAOs perform for DOE pursuant to truancy cases that are investigated and processed on a daily basis. These special deputy marshal powers allow SAOs to execute many identical job duties and functions that the court deputy marshals and probation officers perform in their line of work, in addition to our regular duties and responsibilities. These duties include, but are not limited to, the processing, filing, and serving of legal court documents, the representing of DOE in all truancy cases, the filing of court reports on clients, the monitoring of clients under court orders, and executing apprehension and detention orders of truants who are in violation of their court orders. These three statutes altogether establish the SAO's authorities to, one, enforce the truancy laws. They allow our appointment as duly sworn-in special deputy marshals, and also hold us to the exact same training and physical fitness requirements as every other peace officer categorized under the post-commission law, and therefore they incontestably affirm that we are in fact law enforcement personnel. The question, dear senators, really shouldn't be, are we law enforcement officers? The real question is that we should be asking ourselves is, how are we not? The school attendance officers and I humbly seek your support to address this inequity by voting yes on Bill 40-33 and enact it into law. Thank you.
Thank you very much, Mr. Garrido, for your testimony and also all the attached documents that you provided as part of your written testimony. And just for the record, the testimony that was just presented by Mr. Garrido is also co-signed by 9 other school attendance officers.
Yes.
Okay. Thank you, Mr. Garrido. Ms. Bora, please.
Good afternoon, Mr. Chair, Vice Speaker Cruz, Senator Nicholas, Senator McCreadie. I am Carla Borja, Deputy Director of the Department of Corrections. Although I was recently appointed to this position, I have served the island of Guam and Hawaii in a law enforcement capacity for approximately 20 years. I will be providing testimony in opposition to Bill 40-33 COR as written. The Guam Department of Corrections is mission-driven to protect the public from the destructive behaviors of law offenders through confinement, punishment, and rehabilitation. Today, on a daily average, DOC oversees the care and custody of approximately 750 plus adult inmates and detainees, some of which are convicted or detained for offenses to include murder, rape, aggravated assault, and family violence. The minimum qualifications for corrections officers at the Department of Correction includes being a high school graduate or its equivalent, with the understanding that post may come forth and set a higher academic qualification for applicants as they consider necessary. Have no criminal felony convictions or convictions of moral turpitude or crimes of domestic or family violence, drug screening, psychological and polygraph testing, physical agility test, written examination, and a background investigation. After being vetted and selected through that process, the applicant must still undergo and satisfactorily complete 3 months of rigorous training prior to beginning on-hands employment with DOC, which includes physical training, self-defense, and defensive tactics, handcuffing, firearms, and introduction to corrections. Corrections officers are deemed Category 1 law enforcement officers under the Peace Officer Standards and Training Commission Administrative Rules, and as such are held to certain mandated physical standards in order to maintain a law enforcement status. Without a post-certification, corrections officers cannot function as law enforcement officers. Truancy in itself, as defined, is any intentional unauthorized absence from compulsory education. And on Guam, we know, as we've also heard, that students from the age of 5 to 16 are mandated to attend school. According to information received from the Department of Education, a school attendance officer is tasked with overseeing school attendance and reporting any truancy matters to the court or for disposition. I was advised that to be a school attendance officer requires a minimum of 2 years' experience working with the youth, high school diploma, and a valid driver's license or any equivalent. No mandatory training or law enforcement vetting is required for this position prior to being selected. When you look to compare the two types of employment to include qualification and training of school attendance officers and corrections officers, how do you equate the qualifications and prerequisites of employment as well as the work that is performed? Notwithstanding the excellent work conducted by the school attendance officers in the performance of their duties in assuring that our island youth attend school in order to afford them the basic foundation for a better future, the qualification and work does not exactly equate. Corrections officers put their lives on the line every day, overseeing some of Guam's worst adult criminals placed in our antiquated and overcrowded facility because they cannot follow the laws of the territory. Our officers interact with these offenders daily, both with and without the bars that confine them. But for the training that is provided to our officers before they can be considered law enforcement and the commitment they have all day, every day to public safety and our mission at the Department of Corrections, they get through the day safely in our facility in 8-hour shifts and sometimes longer. Bill 40-33 seeks to reclassify school attendance officers as truancy officers and as such deem them law enforcement officers to be included under the public safety and law enforcement pay adjustment. Being a former juvenile probation officer, I do also understand the dangers that can accompany a pickup order for a juvenile. But as a juvenile probation officer, I was educated and trained to deal with all aspects of juvenile offenses and situations in the juvenile justice system, not just truancy. Should school attendance officers desire to be considered law enforcement officers, it should not simply occur with the stroke of a pen. First, their scope of work should encompass more duties and responsibilities in upholding Guam law other than the status offenses. Secondly, for their safety, they should be required at minimum prior to being hired, either higher education or mandatory training prior to assuming their duties. They should be vetted as law enforcement officers before they are hired and held to that same standard as all law enforcement officers, as with the Department of Corrections, the Guam Police Department, and the Guam Fire Department. Simply changing their status to law enforcement officers in order to afford them a law enforcement pay adjustment and other benefits shows a great disservice to all current law enforcement officers who either obtained a higher level of education or completed an academy of training in order to uphold the laws of Guam and proudly serve and protect its people. Respectfully submitted, Mr. Chair.
Thank you very much, Ms. Boyle, for your testimony this evening. Mr. Miller, please identify yourself for the record.
Vice Speaker Cruz, Senator San Nicolas, Senator McCreadie. My name's Eric Miller. I'm the public defender. It's been my privilege to spend many happy Friday afternoons with these truant officers in Judge Ingles' court. I saw a presentation recently from an attorney who specializes in death penalty cases. That's all he does is death penalty cases. And he said, you know, if you tell me you're representing somebody in a death penalty case, I can tell you one thing for sure about that particular defendant. He was in the juvenile court system. 100%. I do a lot of work in juvenile court. And I can tell you that every one of my files, with almost no exception, where I'm representing a child who's been charged as a juvenile delinquent, meaning that he's accused of doing something that if he were an adult would be a crime. In almost 100% of those cases, that file started with not a crime, but with truancy. That's how important this work is. And as a community, if you want to make a difference in the criminal justice system, you've got to start at the beginning. You've got to catch these kids before they become adults. You've got to get them into school. You've got to keep them in school. And you want the very best personnel out there doing that work. And that's why I think that you should consider them with the same status as law enforcement, because they are out in the field doing discretionary work with these children, and you want to do it right. Because if they're effective in what they're doing, it can change the course of how those children come out at the end. Thank you very much.
Thank you very much, Mr. Miller, for your testimony this evening. Any questions from my colleagues? Senator San Nicolas?
Thank you, Mr. Chair. I'm just trying to clarify now because it seems like I'm getting two different sets of facts. Mr. Garrido, you testified that the truancy officers are completing, you guys are deputy marshals of the court.
Correct. Yes, sir. We are.
Do deputy marshals of the court get law enforcement pay?
We are special deputy marshals.
Special deputy marshals, but the deputy marshals of the court.
Do the deputy marshals of? Yes, they do.
They do. How are special deputy marshals different from deputy marshals?
To my understanding, special deputy marshals are deputized to conduct their specialized nature of work, which is why we are categorized under Category 2.
So none of the deputy marshals can do truancy work. It's just you guys.
To my knowledge.
Okay. And then, as special deputy marshals, you go through the same training as the other deputy marshals?
As under the law, like I mentioned in my testimony, it was required that we take training, which was again developed and adopted by the Judicial Council of Guam, which we have, and we recertify every 2 years.
So you guys go through the same training as
Yes.
as the deputy marshals?
Correct.
Because the testimony from Ms. Borja,
Aside from, of course, the firearms and
Right.
any specialized tactics, if you're talking about like special enforcement tactics.
because the testimony from Ms. Borja is saying that there's no mandatory training or law enforcement vetting this position. No law enforcement vetting is required for this position prior to being selected, but you cannot be a truancy officer unless you go through that training.
Correct. Yeah.
Okay. So I just need to clarify that because I'm not quite sure where that
We wouldn't
statement
be
would come
able
from.
to conduct our official duties unless we went through this training
Okay.
and were certified and sworn in.
Do you guys carry badge?
Yes.
And when you go and you enforce your duties as special deputy marshals, are you going onto private residences, for
We are
example?
going into the unknown, sir. Like what was mentioned, whenever you have a badge on you, pretty much you're made a target. You're the bad guy. You're the enemy. Yes, we go into the unknown and the at risk because of the course of work that we do. Naturally, wherever we go, where it is assumed or presumed to be at risk for us or pretty much anybody.
When you are pursuing a truant, a student who is truant, it's the child that's truant, but who is actually the one breaking the law? Is it the child or is it the
would be,
parent or guardian?
For the most part, it would be the parent and guardian, and of course, those are really the people that are responsible ultimately for all of our children.
So when these cases go to court for truancy, it's the parent or guardian that's going to court.
Correct. Depending also on their age, there are certain minors at their age level that become adjudicated and given court orders.
So you guys don't carry any firearms or?
No, sir. We go in basically with pepper spray and baton.
When someone is found guilty of truancy, a parent or a guardian, what is the penalty by law? Are you familiar with that, having represented because it says you represented the department in court. Are you familiar with what's at stake?
Very true. We are the sole representatives at the preliminary hearings. Your average basic outcome would be the adjudication, a court order that was given either to the parents and also the child, like I mentioned, depending on their age and their responsibility, that they must adhere to going to school, obeying the laws of Guam, the commands of their parents, and basically not miss any more school, whether it's unexcused absences or tardies for that matter.
If someone's just always truant and a parent is just constantly having a truancy case with their child, what kind of penalties will the courts levy on?
Their centers to just let you know, their truancy cases really are very complex. It can be as simple as no transportation. It could be as complex as child abuse, neglect. I mean, we really open a whole lot of can of worms, if you will.
So by bringing a case to court for truancy, you might also be in effect having a parent or guardian eventually getting charged for a higher crime.
Correct, and it has happened.
So I'm just trying to play these scenarios out in my head because I'm trying to understand exactly the nature of your job and why it's law enforcement related. So you're unarmed, you're going into a residence looking for a truant, and at that residence may be the parent or guardian who is eventually going to have to go to court because of that truancy. And as a result of that truancy, there may in fact be even higher crimes that are uncovered by that very parent or guardian, and you're entering that residence unarmed. So that parent or guardian who already has a truancy issue that's going to have to be adjudicated may also be looking at you walking in that door without any armament and saying to themselves, this guy is going to get me eventually busted for child abuse or whatever that might eventually come as a result of taking that child in for truancy.
Yes, sir. In fact, we collaborate many times with the deputy marshals because quite a few, if not most, of our parents that we deal with do in fact have bench warrants or search warrants, and so we collaborate with them. In fact, there were a couple of cases where we went to the household, or a couple of the SAOs went to the household to pick up. They went to the household with the deputy marshals to execute both the apprehension and detention of the minor and the parent. So yes, it's not uncommon at all.
Now I know that the bill is talking about law enforcement, adjusting your salaries to law enforcement personnel. Do you guys currently get hazard pay?
No, sir.
No hazard pay for your work?
No, sir.
Thank you, Mr. Chair.
Thank you very much, Senator St. Nicholas, and thank you very much, Mr. Guido, Mr. Miller, and Ms. Borja for your testimony this evening. I am going to call out the following names, and if by any chance you are in the audience, you're invited to join us up front. And I recognize that there's a request that a good number of individuals not necessarily provide oral testimony. So if you do not join us up front, then I will recognize that in fact you have signed in to show your position on this particular measure. We have Mr. Chris Anderson, Janice Charglove, Anna Charglove, Benny Charglove, Jr., Ignacia Barcenas, Edward Barcenas. If any of you are in the audience and you would like to join us up front and provide oral testimony, please do so. If not, then the committee will recognize that you have signed in as expressing your position on this particular measure. So once again, Mr. Chris Anderson, Janice Charglove, Anna Charglove, Benny Charglove Jr., Ignacia Barcenas, and Edward Pereira. The additional individuals are Eva Camacho from DOE, Yvonne Manglotnya, Ignacio Guerrero, and Arlene San Nicolas. Once again, the additional names are Eva Camacho, Yvonne Manglotnya, Ignacio Guerrero, and Arlene San Nicolas. So I take it all of you have also signed in and have expressed your position on this particular measure. Senators, unless you have any statements you would like to make in regards to this proposal, Bill number 40-33. This concludes our public hearing. Just for the information of the public, the committee will continue to receive public comments, written comments subsequent to this date for the next 10 days, and then we will see what we can do to place this measure on the agenda within the next 2-3 months. Okay, so the next 10 days, the public is invited to provide written testimony to the committee. That concludes our discussion on that measure. I would like to also recognize that there are written testimonies received by the committee, one from Mr. Jose Munoz, another one by Aggie Manuel Cruz, Stephen Pangilinan. We also do have testimony from an Emily Meno, and Mr. Fernandez, the Superintendent of Education, has also provided written testimony as it applies to Bill number 40. So the committee will proceed as stated by receiving written testimony if by any chance the public would like to provide testimony. If any of these, I just received a new list of individuals who have signed in, Mr. Joe San Augustine, Jeff Limo, and Julius Tano. I take it that's for the next proposal, so I apologize. So that being the case, thank you very much, folks, for your attendance this evening and for your oral or expressive testimony in terms of Bill number 40-33. That concludes our public hearing on that particular measure. Ladies and gentlemen, we will proceed to the second item on the agenda, which is Bill number 42-33, with an act relative to the crime of promoting prison contraband, which may be cited as the Contraband Reform Act of 2015. And the sponsor of this measure is Senator Brian McCreadie, and I will give him an opportunity to be able to provide brief comments on this measure. In the meantime, I would like to invite Mr. Joe San Augustine, Mr. Jeff Limo, and Julius Tano to please join us up front if you would like to provide oral testimony. Senator McCreadie.
Thank you, Mr. Chair, and thank you, Director San Augustine, for your testimony today. Bill 4233 was introduced with the goal of providing Department of Corrections a much more comprehensive mandate with regards to prohibiting items entering and leaving the correctional facility. Bill 42 repeals and reenacts Section 5860 of Chapter 58, Title 9, Guam Code annotated to finally update the old prison contraband law. Now, Guam's current prison contraband statute is extremely outdated and hasn't been updated since Public Law 14-146. That was in 1978. Now, many items that are now considered inappropriate in a correctional facility were either not that common or didn't exist when the law was originally passed. Now, this bill, if passed into law, grants the Department of Corrections more legal authority to ban items such as cell phones, which are already prohibited as a matter of policy and practice, but not mandate or law. Bill 42 sets levels of contraband. Regular contraband is a misdemeanor, while major contraband is a second-degree felony. Contrabands are defined in Section A. Now, both have minimum sentences of imprisonment and impositions of fines as well. It is crucial that we amend and fix the prison contraband law to increase security inside Department of Corrections and to ensure that victims and the public at large are less susceptible to retribution from inmates and detainees. I thank you, Mr. Chairman, for allowing me to speak on the bill, and I look forward to any kind of input to make it better.
Thank you very much, Senator McCreadie. I'd like to recognize the presence of Senator Escudon. Thank you, Senator, for joining us this evening. Mr. San Augustine, if you can just identify yourself for the record and proceed with your testimony.
Good afternoon. Acting Speaker Cruz, Chairman, Senator Brian McCreadie, Senator Escudon, Senator San Nicolas, and good afternoon. My name is Joe San Augustine, and I am the Director for the Department of Correction. At about 3 p.m. this afternoon, my perimeter officers were driving around the perimeter of DOC. Coincidentally, they identified an individual, supposedly in white shirt, walking around the backside of the perimeter with 2 items in that individual's hand. The officers proceeded to pursue the individual in the backside of DOC, which is on the eastern side, close to where the dome, what we know as the dome, and apparently the individual disappeared. So I couldn't say much with the exception of that I favor this bill. So with that, I will go ahead and proceed if you allow me to go ahead and read my testimony. Salute as an alpha day, Senators, Mr. Chair, Speaker, members of the Committee on Guam, U.S. Military Relocation, Public Safety, and Judiciary. I am Joe A. San Augustine, Director for the Department of Corrections, and I am here to provide support for Bill 42-33. An act to repeal and reenact subsection 58.60 of Chapter 58, Title 9, Guam Code annotated relative to the crime of promoting prison contraband, which may be cited as the Contraband Reform Act of 2015. The current law promoting prison contraband per subsection 5860, Chapter 58, Title 9, annotated describes a person who commits the offense of promoting prison contraband if, 1, he or she intentionally conveys a dangerous instrument or a controlled substance to any person confined in a detention facility or in the custody of, being a person confined in a detention facility or in custody, he or she intentionally makes, obtains, or possesses a dangerous instrument or controlled substance. A controlled substance may be possessed by or conveyed to a person confined in a detention facility only in the custody of the facility administrator express approval and under the medical supervision. Promoting prison contraband is a second-degree felony. I say this because I actually took this out of the old prison contraband law. And as you all can see, it's very vague, it's very dry, it does not have much substance. Throughout the years, items such as tobacco products were considered restricted in government facilities through Public Law 30-63. These products are now considered contraband in a correction or a detention institution. Additionally, violation of promoting prison contraband either through air delivery, items tossed over the fence, or contrabands brought in by visiting family members has been an ongoing challenge. As it is the Department of Corrections' mission to protect the public from the destructive actions of law offenders through rehabilitation and education, it becomes difficult to rehabilitate if there are no laws in place to hold violators accountable. The great men and women of the Department of Correction welcome these enforceable mandates that can deter inmates, detainees, and the general public from promoting or possessing contrabands in such a dangerous environment. The initiative of Bill 42-33 will provide for a more stringent punishment or penalties to individuals who continue to violate or undermine the law. With that said, I'm ready to proceed for any questions or concern regarding my testimony.
Thank you very much, Mr. Director, for your testimony this evening on this particular measure. Senator McCreadie?
Not a question, but when you alluded to the gentleman in the white shirt at 3 p.m. today, were you insinuating that is that a prime suspect for contraband? Is that what you look for?
That is one way of contrabands making their way into the compound. It's become very common that, as I indicated here, air delivery. It's very common that they come around at certain hours and throw contrabands into the facility. What's common when they do that is either chewing tobacco, cigarettes, or chewing gum.
Now, when you experience contraband offenses, bringing it into the prison, do you have a data of who brings what in? Do you experience language barriers that maybe someone didn't understand what contraband was? Is it an absolute intent to commit a crime all the time, or do you see some cases where a misunderstanding and language barriers?
And that's a good question, Senator. I could tell you they clearly know that they're violating the law. If they knew that it was allowed, then they could go ahead and come in the front door and sign in and say, I'm here to drop it off. But when they're wrapping it in such a fashion where to conceal it, and there are times where we actually do find drugs in those items as well that are thrown over the fence. So that's one of the primary way that it's making its way in the facility.
And what would you say is your biggest problem in contraband? Is it cell phones or technology? Is it drugs? Is it alcohol? Is it weapons?
Weapons is not so much. Cell phones are very common. Cigarettes and chewing tobaccos are very common, and drugs as well. More difficult for us to find drugs because simply the way it's packaged. And of course, they come at a smaller content or baggage. Cigarettes, chewing tobaccos are very easy to identify. Cell phones as well. Earlier this week, actually over the weekend, they were able to retrieve 2 cell phones, brand new cell phones, on the west side of the facility, closer to where the galley is at. So, people will do whatever they could to try to sneak these kind of things in. Again, we just need to continue to be very aggressive and attentive to what we do up at DOC.
And one more, Mr. Chairman. Is there any literature? I know I've been to the prison, but I don't know if I enter from the same entrance as the visitors. But is there any type of literature that says what the law states and what the punishment is if they do bring contraband in?
No, actually we do have it, but it's not clear. It's starting to fade away. We do inform people that visitors that when they do violate, if it's not anything, like a weapon, their visitation will be restricted.
The reason why I asked, because if this bill was to go through the vetting process and get passed and signed into law, I think that an amendment that we could consider early on would be to put some type of literature and some kind of educational program to the visitor. If you have contraband and if you're thinking of passing that along into this facility, here are the punishments. And this will, we give fair warning before they try and pass that through the facility.
And we do have that.
Okay.
Yes.
Thank you very much, Senator McCreadie. Any other questions for Mr. San Augustine? Senators? If not, the chair is going to apply the prerogative as it applies to Bill number 40-33 and Bill number 42-33 and prepare the committee report by the conclusion of this particular week. So just for the information of the public, I'm going to rescind my initial statement with regards to the earlier legislation and work on having both proposals reported out. I know the good sponsor of Bill number 42-33 has requested that be reported out by the conclusion of this week, and there's been also requests by individuals in the community who have provided testimony in the previous legislation to see if that can be reported out within that same timeline. So the committee will be reporting it out. So if by any chance the public would like to provide testimony on either of these measures that have been entertained this evening, I would like to request that it be transmitted and submitted to my office no later than 10 a.m. on this Friday, the 13th, 10 a.m. this Friday morning. So that being the case, these particular legislative measures have been publicly heard, and the committee is hereby concluded. Thank you.
Senators, thank you. Have a good evening. Thank you.